Hey everyone, I hope everybody's doing well. We've been doing this little series on estate planning, and we've done a number of videos. And the first one we did was, why estate planning is important. And we went over the 7 reasons why we thought that estate planning is important. The second little video we did was what happens if you don't have an estate plan. We talked about you being subjected to both living probate and probate when you pass away, as well as the state stepping in and dictating the process and dictating who is going to get what you have. The third video that we did was, what should a basic estate plan accomplish? And the number one thing that we thought that a basic estate plan should accomplish was to avoid probate, to take the state out of your business, to take probate completely off the table, both living probate and probate when you pass away. We also said that a basic estate plan should leave you in control of your assets, both while you're alive as well as when you pass away. We do not want your business to become public knowledge. Basic estate plans should protect you and your family from everything being public. We want to avoid court. We want to avoid the cost of court. We want to avoid attorney's fees. We want everything to be easily administered. So that was the third video that we did, which leads us up to, we've talked about, why estate planning is important, what estate planning should accomplish, what happens if you don't have an estate plan. So the next one we want to talk about what types of estate plans are available. And really there's 4 types. The first type is the ever popular do nothing plan. Where people say, you know what, I just don't have time for it. I don't have time to get my ducks in a row. And next thing you know, it's too late. You've either become incapacitated or heaven forbid, you've been involved in a tragic accident, you passed away, and it's too late. So that's the ever popular do nothing plan. The second type of plan that we're going to talk about is the will-based plan. Everybody has heard of, you need a will, you need a will, you need a will. And there are a few advantages to having a will, especially over the do-nothing plan. And then the other 2 plans that we're going to talk about, we'll do that in the next video, are trust-based plans. The first is a revocable trust-based plan, which is basically a will replacement, and then the last would be an asset protection plan. But today, we're going to talk about really the first 2, the do nothing plan, which we're not going to spend a whole lot of time on because we basically kind of covered a lot of the highlights of that type of planning, if you want to call it planning, and then the will-based plan. So with the do nothing plan, again, you're subjecting yourself and your family to living probate in the form of guardianships and conservatorships and all of the costs and the publicity that goes along with that. Okay. We talked about you'd have to pay attorney's fees, you have to pay guardian ad litem fees, you have to pay court representative fees, which a court representative would be an attorney. You have to pay publication costs, you have to pay court costs. The time that it goes to get all this set up is very, very expensive endeavor. And before I said that probate is big business for attorneys, and it is, and those are the reasons why. Because, at some point in time, whether or not we want to face it or not, we're going to be faced with our own mortality. And we also may be faced with incompetency or debilitating illness, such as a stroke, a heart attack, a car wreck, something that debilitates us. So we're all faced with that. So that's why probate is big business for attorneys. So under the do nothing plan, you have the expenses of court, you have the publicity that's associated with it, you have the state stepping in and dictating the process. You have a judge who makes rulings on the process. You have the state dictating who is going to receive your assets. So that's the first type of estate plan that we're going to talk about today, that we want to discuss today. The second one, and then we'll spend a little bit more time on this one, is will-based estate planning. Everyone has heard, you need a will, you need a will, you need a will. Well, there are advantages to will-based estate planning in the fact that, number one, you get to decide who is going to receive your assets. So if you want Johnny to receive the truck, you can state that I want Johnny to have the truck, I want Stacy to have the piano, I want Judy to have the bedroom suite. So that's an advantage over the do nothing plan. At least you get to decide who gets what you own. However, it does not remove probate from the table. You're still subjected to living probate in the form of guardianships and conservatorships, and probate when you pass, because a will does nothing for you while you're alive. For your will to be effective, for your will to be enforceable, two things have to happen. The first thing is you have to die. Okay, again, like I said, a will does nothing for you if you become incapacitated. A will does nothing for you if you have to go into an assisted living facility, or if you need long-term care in a nursing home. A will does nothing for you for that. So the first thing that has to happen for that will to be enforced is, number one, you have to die. The second thing that has to happen is it has to be submitted to probate to be enforced. Okay, I can't tell you how many people come to me whose parents have passed away, and we get the phone call saying, hey, my dad passed away, I need you to come, and I need to come in and let you review the will. And we say, okay, sure, come on in, we'll be glad to do that for you. And after reviewing the will, I tell my client, I said, well, we have to probate this will. And his next question to me is, well, why? I said, well, because he has a will. And if we don't probate this will, it's not worth the paper that it's written on. So for a will to be effective, it has to be submitted to probate. And through probate is when it is enforced. So it has to go through that probate process from beginning to end. You have to pay attorney's fees, you have to pay court costs, you have to pay publication fees. You have to go through the time frame that it takes from point A to point Z to have that will probated. And during that time frame, you hope that siblings don't get crossways. You hope that they don't start butting heads and then tension starts to boil. Which that does happen quite a bit, because maybe one child doesn't agree with exactly what it is that the dad wanted. Maybe dad wanted, like I said, Johnny to have the truck, or maybe Susie wanted the truck and Johnny wanted the piano, and mom said, or dad said, I could have that picture. And then when that starts, then you have conflict, and then you can have will contests. So with will-based planning, the advantages are, well, number one, it doesn't cost a whole lot of money to set up a will. It doesn't. As a matter of fact, as an attorney, when I graduated law school, we knew a lot about the law, but we did not know anything about the business of law. So our professors told us, they said, the way that you establish a law practice is you go out and you do as many wills as you possibly can do for as cheap as you can do them. Because at some point in time, your clients are either going to become incapacitated, they're going to need a guardian or conservator, or they're going to pass away and you can probate that will. So by going out and doing as many of these wills as you can possibly do, you are then establishing basically a built-in probate practice. So those were some of the ways that our professors told us to build a law practice. Is just go out and do as many wills as you possibly can and do them for as cheap as you can do them, because they're going to come back to you to have these things probated. And that's where you make your money. That's where you build your clientele, through probate, living probate, or probate when you pass. So wills are big business for attorneys. You don't see many attorneys recommending revocable trust, and that's the reason why. It's because it is big business. Going through the probate process and having to hire an attorney and do all that, that is big business. And again, the only way it really differentiates from the do nothing plan is the fact that you do get to say, I want this person to have this asset. I want this person to have this asset. I want this person to have this asset. The state doesn't control that, but the state does control the process. That you still have to go through the probate process, and you're subjecting yourself and your family to not only probate when you pass away, but also living probate. So if you have a will and you want to discuss your will with us or discuss other planning options to take probate completely off the table, you can call us. You can call us in our Dothan office at 334-792-6213. You can call us in our Fairhope office at 251-333-9371. You can also go to our website. You can send us an email through our website, or you can message us on Facebook, and we'll be glad to answer your questions. Now, if you call us, we don't charge for phone calls. The first 15 minutes is free. You'll talk to either myself or you'll talk to my paralegal, Robin, and we can help you and answer your questions with regards to your estate plan and how your estate plan would be administered if something were to happen to you. So next time, what we want to talk about is we want to talk about trusts. We want to talk about revocable living trusts and the fact that most of us have heard the word trust, but a lot of us immediately think, well, I don't have enough money to have a trust. Well, I can tell you there are more different types of trusts out there than I have fingers and toes. There are trusts that were designed for the Waltons and the Trumps and the Kennedys of the world. And then there were trusts out there designed for people like myself and yourself, that have modest baby estates, and we just want to avoid probate. We want to make sure that our children aren't arguing over everything. We want to take probate completely off the table. We want to minimize the involvement of attorneys, court costs, publication fees, attorney's fees, and all of that. So we'll talk about trust, in particular, like I said, the revocable living trust, which is a will replacement, and the asset protection trust that can be used to protect your assets from creditors, predators, and the nursing home. So I know a lot of you have heard people, maybe know of someone that had to literally sell the farm and give the money to the nursing home because someone got sick and they had to go into the nursing home, and all of the money was spent. The land was sold, the money was spent, and maybe the surviving spouse, or what we call the community spouse, was maybe left destitute. Had to sell the home, move in with children because they can no longer afford the home. So asset protection trusts help protect from that. So we'll talk about that next time. Again, if you have any questions, please feel free to call us, send us a message. We'll be glad to answer your questions. So until next time, I hope everyone stays safe, and we'll talk to you then.